The whole country is getting ready for Judge Masipa to hand down her verdict in the Oscar Pistorius trial today in the North Gauteng High Court. But yesterday, Judge Masipa had ruled out the fact that Oscar Pistorius is guilty of murder, either by dolus directus or dolus eventualis. That means that a potential charge left for Oscar Pistorius, or rather a potential conviction, is culpable homicide. Now, we caught up with criminal law expert William Booth, who described what could potentially happen to Oscar Pistorius if he is found guilty of culpable homicide or killing somebody by his own negligent means.
You could have a situation of culpable homicide. In other words, the negligent killing of the intruder. And because Oscar's version has been that he believed, although mistakenly so, there was an intruder, and that he acted, although mistakenly so, in self-defense. So even if his version is accepted, the court could still find him guilty of murder with regard to the intruder if it finds that he went beyond what he was allowed to do in terms of our law pertaining to self-defense.
Now, despite the fact that Oscar Pistorius could face a culpable homicide charge at the moment instead of a murder charge, many people, legal experts around the world, seem to be indicating that they believe Judge Masipa made an error of law when she ruled that Pistorius hadn't murdered Reeva. Which brings up a very interesting point. Can the state appeal Judge Masipa's ruling? Well, you see, Clarinel for the state can't simply appeal the ruling based on the fact that he didn't like the outcome, but he is allowed to appeal the ruling if he believes that Judge Masipa misinterpreted the law or didn't apply the law correctly. So it's entirely possible that Clarinel may then go ahead and appeal Judge Masipa's ruling based on the fact that he doesn't believe that she correctly administered the law in throwing out Oscar Pistorius' murder charge. Here's how this could work.
If the state feels that they wish to appeal, and they can only appeal in a limited way on the law. So in other words, if they feel the judge has made an incorrect ruling pertaining to the law, for example, what the law says as has been handed down by other precedent cases previously, and how it's been developed, and if the state feels that the judge has made a mistake in respect of the law, the state could lodge an application for leave to appeal.
Who do they appeal to?
They appeal to the same judge. If that judge turns down the application for leave to appeal, they can petition to the Supreme Court of Appeal, and the Supreme Court of Appeal could then make a ruling that the appeal will then continue at a later date, or they could appeal to the Constitutional Court if it's an issue relating to the Constitution. So those are the avenues that will be open to the state.
And of course, we do know that the defense are well within their rights to appeal a ruling by Judge Masipa. It could go like this.
An appeal can only take place after the sentence is handed down.
Now, it's pretty safe to assume that should Oscar Pistorius be found guilty on one of these counts, his defense would appeal.
Well, I think it depends on the sentence. On the other hand, even if they get a non-jail sentence, let's say on a charge of culpable homicide, I feel that, because a criminal conviction has a major impact on anybody, and he hasn't got any prior convictions, there could be an appeal even if he's convicted on a lesser charge, and even if that court decides on all the evidence, on all the mitigation and aggravation, that an appropriate sentence is one of non-custodial type, they might still appeal. But don't forget, there's always the risk if you appeal a conviction and a sentence, the higher court could possibly, in certain circumstances, increase that sentence.